My name is Julian Novak. I'm an associate professor here in competition law, and I today took over from Thomas to chair this event. And I'm particularly pleased to introduce to you Björn Lundqvist, who is a professor at Stockholm University. He's also the chair of the Swedish Network for European Legal Studies, director of the European Legal Institute, European Law Institute in Stockholm, and the director of Ascola Nordic. And in that capacity, I know him pretty well. We have been working together for years when I was still in Sweden, and I'm so glad to have him here today. And he's going to basically talk about his book, Regulating Access and Transfer of Data, which came out with Cambridge University Press. And oh, wow, it's already 2023, but that's just how time flies. I couldn't imagine anyone better to talk about this topic, because Björn is actually an expert in exactly that kind of interface between competition law, as a competition lawyer, intellectual property, technological barriers, data protection rules, and that's essentially where it all kind of mixes in regulating access and transfer of data. And in that sense, I'm super happy that he could join us and talk about his book. But at the same time, I'm even more delighted to have Sandra here joining us from CUHK, who has kindly agreed today to act as our commentator. And she's basically providing a bit of an answer to what Björn says. And I'm particularly glad that she agreed to do so on a very short notice. We basically were this morning discussing it, and we knew that she would be coming. And so we asked her whether she would be willing to do this. And she just said, yes, I'm happy to do so. And so I'm very happy, and I'm looking forward to a very great discussion. Björn, over to you.
Thank you. Thank you for the kind introduction, Julian, and thank you for inviting me, Thomas. And it's very nice to be here. First time in Hong Kong, so I'm happy to be here, and it's a very lovely university and lovely town, I think. Thank you. Good. So I'm going to present my book, Regulating Access and Transfer of Data. Just a little bit of a background note is that it wasn't meant to be a book. I started to write an article about access to data under competition law. And then the pandemic hit. So I just kept on writing at home, and it turned out to become a book, actually. And yeah, so that's the background. That's why I have a competition law perspective on it. While, I mean, if I would start from the beginning again, I wouldn't start with competition, actually, but that's how I started. Great. Another point of departure when I write this is also the Internet of Things, which we heard much about today, actually. And this idea that everything in society more or less going to collect data from us. I mean, our clothes, our cars already actually do pick up a lot of our data. I drive an old Saab, if anyone knows that brand. It doesn't pick up any sort of data from me, but if you buy a new car today, it really pretty much follows you around, and you can from the vehicles, movement of the vehicle, where you park and so on, you can pretty much pick out a lot of information from the driver and also the other individuals in the car, actually. But anyway, this is going to multiply in the Internet of Things, and our clothes, vehicles, bathrooms, houses, and cities, and everything is going to collect data from us. The consequences of that change is kind of difficult to predict, but it seems quite clear that this data is important and it holds a value. Then it depends a little bit who actually values it or for what, but at least the presumption is that this is going to be very valuable. Another point of departure, which I often discuss actually also with the students, is that the data which is picked up from various sources or the information as such, irrespectively of how private or how valuable it is currently not covered by property rights. I mean, yes, there can be copyright protection to data if there's a, you know, if it's a poem you write on Facebook, but from the starting point is that data or information as such is not covered by property right. Given that, though, I mean, if you look at practice, there are a lot of contracts today written as that data would be a property. I mean, there are data contracts, you transfer data, you buy data, and in practice, it is considered at least as a very valuable asset, and also in many ways as a property. Also, then, used to know what we call data today was called big data before. I mean, it has different sources. When I started to look at data from quite a long time ago, at least when it came to accessing government data, then government data was the big thing. Everyone wanted to access to government data, you know, maps, address for people to send ads to them at home, where are the post offices if you have a map, and the idea was actually to open up government data for companies to make innovation and be a basis for innovation and new sort of services and websites, if you want that. And I will come back to that a little bit, because that was the first of the legislation actually in Europe about accessing data and transferring data. Nowadays, of course, it's the big black box. You have data from different sources, government data, but then, of course, voluntarily provided data or user-generated data, which would be the big thing in the Internet of Things. And you connect that data to AI. And in many ways, at least before this AI was developed, then everyone said, no, it's the data which is the important thing. The quality of the data is much more important than actually the sophistication of the AI model. If that is true or not, it's difficult to say today. We start to get a lot of synthetic data in many, especially in the US, that is the big thing. However, still, it seems to be, if you talk to the people in the industry, they say, well, still real data coming from real people or real business transactions, whatever you have it, is still much more valuable than synthetic data. But AI is the black, model, which nowadays, runs and is run on all this data collected. It's a little bit interesting, and these numbers are a little bit old, I think. Since coming from a competition law perspective, I wanted to identify a market failure. Like, is there a market failure in reference to access data and transferring of data on the internet? And if you look then, especially around all these reports, which was written by European and Asian and American public authorities, but also universities and so on, around 2019, it seems to be quite clear there is some kind of market failure, or at least the idea that was quite prevalent before that was that, yeah, we will have all this data, everyone will transfer data, this will be bought and sold on the internet, and you can transfer it. But due to certain scandals like Cambridge Analytica, for example, it's quite clear that the large platform, or as we call them in Europe, gatekeepers, are not selling data at the level that we presumed, at least, when this data economy was hitting off. I think the CMA report from 2020 is quite interesting. So the CMA, which is the UK Competition Authority, they did an analysis of the 100,000 most popular websites in the UK. They identified that 83% of those websites collects data, and 83% of them also collects data on the behalf of Google. So it's not only that the Google ecosystem collects a lot of data, they also gain a lot of data from other websites, which doesn't say it's Google, but uses Google technology or uses Google services, and thereby also agreeing to transfer data to Google. So the interesting thing, if you take Google, for example, is that they do collect a lot of data from their own ecosystem, but they also collect a lot of data from sources that we cannot see that we are actually transferring them data. The same thing is actually with Facebook, but on a lesser extent. They collect a lot of data from their own walled garden, but they also collect a lot of data from third-party websites. The other large firms like Microsoft, Amazon, and so on collects less data from third parties, but collects data from their own websites. They also do not really transfer that data to smaller companies, or they don't sell it. What they do, it seems to be, is that they go further up the value chain and sell more sophisticated services. And they keep this data for themselves so that they can actually provide these more sophisticated services while not giving away the raw material, so to say, to other companies. That can then create a problem which I indicated in the book, about like a hold-up problem or locking problem. Even to that the data which is collected is not actually efficiently used by all firms available. If data is the raw material for all new innovations, then there's a lot of this should be distributed for all small companies or large companies so they can innovate, but it's not. It's actually kept inside large gatekeepers. And the incentives, of course, is quite clear to see today. The large gatekeepers compete for our attention when we are on the internet, or they compete. And now they say they also compete actually about in reference to intimacy. If you have an AI model, that AI model is going to be very very nice to you because you need to be on it and they want to keep you there. So it's the competitive advantage is actually who can create the most AI who's most intimate with the user, of course within limits, but that's it's a quite interesting notion of how actually to compete. But I indicate and I identify in the book that data as a source of new innovation is not efficiently used, and that can be a problem to create new forms of innovation. Then, can competition solve that hold-up problem or market failure? Well, I'm starting to shift a little bit here. I mean, back in 2020, 2021, 2022, it was quite clear that competition was seen, at least from a European perspective, as way too ancient, or it didn't really work to solve these market failures. It was a legal system, focusing on efficient analog firms, active in one core activity, and not speedy enough, and it was have too many steps to find a violation. The safe harbors was too broad. The essential facility doctrine is too difficult to fulfill. Also, if we fulfill it, it takes forever to go to court and so on, and it's also very expensive, even for the public, in reference to the platforms. Nowadays, I might shift there a little bit. We do see a lot of new cases on the competition law in reference to the gatekeepers. And we see a lot of new doctrines being developed actually on the competition law. But back then, that was not, at least not from a EU perspective, to be the truth about competition law. Competition law was not seen to be the tool to actually utilize against large platforms not granting access to the data that they collect. So what was the solution? Well, you probably know the solution. There was this sector-specific regulation, and primarily it was a sector-specific regulation which is called Digital Markets Act, which was primarily the first one on the EU, which is a very sector-specific in that sense. It only focus on few very large gatekeepers. Of course, it still applies to the whole of internet or Internet of Things, but it only applies to very large gatekeepers. But the interesting thing, that was just the first step. we start to see, and at least in the Nordics, we see it as a tsunami of new sector regulations coming out of Brussels in all aspects of reference to the internet economy, or the data-driven economy. And I try here to list some of those new acts, which has actually been enacted after the Digital Markets Act. So we have the Digital Service Act, that came quite soon after the Digital Markets Act. We have the Data Act, AI Act, the DPS2, which deals with financial data. So when do banks need to transfer data to a competitor, often fintech, a small company? Well, they have to. They are obliged to do it under the DPS2. If you agree to it, then they have to transfer the data they have in reference to your banking account and what you do on your internet bank to a fintech company, often a small competitor. We have the Data Free Flow Regulation and the Data Governance Act. Data Governance Act deals with government data. Government data is also open the data of the PSI directive. And the latest development, we have this new, which is the first in a number of 14 new data regulations, and that's the health data space regulation. That's the first one. It's going to be 13 more than on different sectors. We start with health, but then we start with transport, environment, whatever you have it. And then, of course, we also have the more general one, GDPR, dealing with privacy. I think, and this is why I argue in the book, because this happened while I was on leave at home during the pandemic. Not many of these proposals was actually launched in Brussels. And in many ways, this is a whole new legal system being developed at an instant fashion, actually. Very quickly are we starting to get a whole new of regulations only catering to the internet, different sectors, different angles to pretty much the similar problem. But the interesting thing, at the heart of almost all these regulations, which are stipulated up there, with some exemption if you take intellectual property regimes and so on, at the heart of that is actually the regulation of access and transfer of data. They have rules, all of them. Also, when do you have right to access data from someone, be it a big bank, be it a gatekeeper, be it a pharmaceutical company, if we take health data spaces? And when can you take that data and transfer it to someone else or to yourself? And the interesting thing with all of these, that they have small specific peculiarities, let's say that. So in some regulation, you only get access to raw data. In others, you get access to more than that. You get access also to fine and, more sophisticated data. Sometimes it's a hard rule. You have a right to access data, and we'll come back to that a little bit. And in others, this is it's more embedded. It's like someone has an obligation to give you data under certain requirement or certain situation. Does that imply that you have a right to that data? It depends a little bit how you can view a hard obligation as someone has a right to access the data, but it's a little bit different in the different regulations. The interesting thing is also that all these regulations are overlapping in one way or another. I mean, it seems like you can access under the Digital Markets Act data from a gatekeeper in certain situations. But if, let's say, you fail in that attempt, then you might go to the Data Act, and then you get access there. So from a legal perspective, going to court, for example, you probably use a number of these acts to try to actually access data. On the other side of the coin, it also implied that the defending party, let's say that, who controls the data and possibly do not want to give access to the data, has a lot of different exemptions that company can use. I mean, you can claim, which often happen nowadays, at least in the Nordics, a large platform say, we would love to give you the data, but this is personal data. This is personal data from the driver of the vehicle. So we're not going to give you that data because, you know, we have GDPR. We cannot violate GDPR giving you the data. Or this, no, but this is protected by intellectual property law. You know, this data is actually a database, and on the EU law, you have a database right to that. We're not going to give you that data. Or it's a trade secret. This is our trade secret. What we have understood from the data we collect, because we have a black box in your factory that collects everything that you know, is done in your production process. Yes, it's inside your factory. Yes, you bought it. But we have a small sensor in that, and we pick the data, and it's our trade secret. It's not yours, it's ours. So it's there, you know, here we see a huge legal system being developed around different issues, but I think mainly, it's my interpretation, mainly on the issue actually who controls the data or who owns the data. Remember, I started out saying we don't have a property right to data. But if you start looking at all these regulations, we are possibly pretty close to having a property right to data. It's just we don't say it, which is kind of odd. But I'll come back to that a little bit. I marked two of these acts in red, and that's the one I'm focusing on today, actually. So let's talk a bit about the Digital Markets Act. And maybe you know everything about the Digital Markets Act. So, but then this is a little bit of a review. It's specific in that sense, and that's why the US government doesn't like it. It's specific in that sense that it caters, I would say, to large, mainly US platforms. Nowadays, of course, it's also applicable to platforms based in China, like Alibaba and so on. So it's also applicable actually to them. But they are quite a hurdle to get in. You know, you have to have an annual turnover at least 7.5 billion euros, which is a lot of money, a market cap of 75 million, and you need to have a lot of users each month. But if you fulfill that, and there's a decision on that from the Commission in Brussels, that you are a gatekeeper, then there are a lot of obligations that you need to abide by, and they are just listed in Article 5 and 6. And the interesting thing, I guess, from a competition law perspective, they're quite specific obligations, but there's no exemptions to it. I mean, if you fall here, you need to abide by those obligations. For example, in competition law, you normally, yes, we have also blacklists about, you know, what kind of clauses you can have a licensing agreement, for example. Can you have a grant back clause or not? But these but there still is an analysis whether this is efficient or not. You know, you can always claim on the competition, but this benefits consumers. And let's do a full-fledged economic review whether this is benefiting consumers or not. And then you might be able to you know, fulfill the rules, and you don't have to, you know, abandon your licensing agreement. There's no such exemption under the DMA. There's no efficiency defense or no defense at all, pretty much. If you fulfill, you need to abide by the obligations. We're not going to go through all the obligations, but I think they're quite interesting. We can just pick a few at least. The first obligation is a prohibition to combine personal data from the gatekeeper's platform services with personal data from other services. It comes, and I put that in the right line. It comes actually from the Facebook cases, which were, the origin is quite clear, competition law cases. They thought it was too complicated to do it in competition law, so now they just put in an obligation saying that, if you are a large gatekeeper, for example, Facebook, or Google, you may not take personal data from one service and combine it with another. So let's say we don't have to take Facebook, let's take Google. If they collect your data from you because you search on certain words, they may not collect, you know, combine that with the data from the mapping services, which is something they actually did. You know, if you were exposed to an ad, then for shoes, they could actually follow you, see if, are you actually going to a shoe store afterwards? And they actually sold that kind of service. It's quite a good service, actually. I mean, it opens up the black box for marketing. You could actually, then you could go to Google and say, if I put an ad there, I can actually see how successful it is. How many people are actually buying my shoes? Give or take. I mean, you need to calculate it. But you cannot combine it. There are also other sorts of obligation. You cannot use price parity clauses, but we can skip them for a while, and then we can perhaps go back to them in time. Article 6 has also then a number of obligations. And on the right-hand side, you see also the origin, the cases, which this is my analysis, where they actually originate from. Many of them are, considered data. I will come back to those. I can point out to some other which are creating a lot of problems at the moment. For example, there's a prohibition nowadays to self-favoring. So you cannot, DMA prohibits safe favoring. That's the Google shopping case, which has been going through all the courts at the EU level, now actually being private. There's a lot of private action cases in Europe about this. And the interesting thing about that, those private action cases, which is a lot of money, all facing Google. There's one at the Stockholm City Court. Klarna, if you know that company, is suing Google for 7.7 billion euros. That's a lot of money. Huh? And the funny thing now is the court is then saying, yes, we have this competition law case, but now we have a prohibition against self-favoring. Does that prohibition against self-favoring, does that influence our competition law analysis? Remember, I talked that everything is overlapping nowadays. Could you use that and say, well, but here the legislators told us what self-preferencing is. That outcompetes, what the court said, because this is a legal act. Well, anyway, it was a sidetrack, but it's quite interesting obligations. If you look at the DMA, in reference, and we already talked about 5.2, about combining personal data from one service to another. But I would like you to look at 5.2 and 6.2 and 6.10. So 5.2 says you cannot combine. Yes. 6.2 deals with Linda Kahn's article and also investigation from the European Commission dealing with Amazon. And the idea, the suspicion they had was that Amazon, they utilize their advantage in data to outcompete business users of Amazon Marketplace. So let's say we have a very successful designer in Hong Kong. And she walks around Hong Kong, trying to sell her new clothing line. Not very successful, but she goes to Amazon Marketplace and starts selling. Maybe it hit it off. She makes a shitload of money. No, but she makes a lot of money. Sorry. But she has no idea really who's buying her clothes. I mean, she gets money, she gets that kind of information she gets. But of course, on Amazon Marketplace, the people buying her clothes could live in Stockholm, or they can live in London or New York, whatever it is. She doesn't really know. She only knows that she's selling. Maybe then she stopped. The sales are dropping. She's not selling that much, and she goes on Amazon Marketplace and she starts to say, "Well, Amazon." Well, that's a copy of my address, and Amazon is selling it. And Amazon seems, maybe she doesn't even see that, because Amazon, knowing everything about the buyers, knows what other clothes they buy, what shoes they wear, what books they read, and everything else, has used, copied her stuff, but then use a private label and then starts to rank her lower and then rank their stuff higher. And even perhaps push her away because they know, well, we know what books to buy, so let's just push it there, our new private label. And then she slowly and steadily loses sales while Amazon is selling more and more. Well, according to 6.2, Amazon is not allowed to do that anymore. They cannot collect data from when she sold and use that in competition with her. That's that's the obligation they have in 6.2. And 6.10 says, hey, not only can Amazon not compete using that data with her, that data is actually her data. She gets access to that data and not Amazon. That's 6.10. All of it is obligations. And one big issue at the moment in Europe is that a right? Does that imply she can go to court and claim that right for that data? And it's being played out now in German lower court. It seems to be so. The court saying that, no, this is a clear-cut obligation. Someone needs to have a right. So a little bit interesting. The Data Act, and I think this should be more discussed than what it is. The Data Act is the lex generalis when it comes to data regulations in the EU. That's the one who should be applicable to all and everything. The whole Internet of Things, cloud computing, everything concerning data. It's now in force. I don't think any company in Europe is actually up and running to understand, but it's now in force, actually. Interestingly, firstly, is that it stipulates mandatory contractual obligations that needs to be inside these contracts. So if you buy a car or if a company buys something with a sensor in it, this law tells them, the two parties here, what they need to have in their contract. It also, and thereby also states when can you as a user of this black box that you need to have in your factory or the car or the lorry or whatever you have that's a sensor in it, when you can access that data which is picked up by this product. And when can you transfer it to a third party? And the interesting thing, because firstly, this is a huge step for the EU because they normally have never regulated contractual relationships before, or very little. This is, and it's also, at least from my university, if you talk to the contract lawyers, they never go to EU law. And now, and you say, hey, you probably have to look at this law now because it's contractual regulations here. And they're like, what? So, but it is. This is contractual relations. FRAND regulations and so on. We can talk about how it should be viewed from a competition law, but it's almost like a block exemption. It's quite similar, actually. It does talk a lot about the access to transfer. Start out with that. The act is this thick, 200 pages. Starts out with the rules about access and transfer of data. And it does, for the first time, say that you have a right. When do you have a right to this data? And when do you have a right to transfer it? There's lots of exemptions. This is going to be litigated like crazy. Security came in here. It's a lobbying thing, I think, from large gatekeepers. So it's a black hole. No one knows what that implies. Non-compete clauses are allowed. So if you transfer data to me, I'm not allowed to compete. So if I buy a BMW, new BMW, they collect a lot of data from me. So I'm not allowed to compete with BMW, which I never will. But I'm not then allowed. But if I transfer that to Volvo, then Volvo can come in a situation where they cannot compete either with BMW. So a lot of oddities here, but that's how it is. We see what happened. But it deals a lot with rights and when you can access and on. Some points of concern, and this is my next to last slide. From a property perspective, and we started out competition law, but let's talk about property. I think it's kind of odd. The whole, especially the Data Act, which we didn't discuss in detail, but I guess on the Hong Kong civil law, and at least on the, I think in many jurisdictions, normally if you buy something, then all rights to that falls. So if you buy a house and that has apple trees, then there's no way that the seller can come back when it's a fall and say, well, by the way, I'm just here to collect the apples. There's no way that could happen. I mean, it's obvious. I bought the house, the apple trees was inside the house, in the garden. No one has the right to the apples but me. Yeah? However, if you buy a BMW or you buy the black box you need for your factory to produce whatever you produce, then you need to agree, according to the Data Act, that the seller of that thing is going to collect the data, and you have a limited right to that data. And that's a kind of a new step, I would say, in the property regime in Europe. There are exemptions to this, and there are exemptions when they have to give me access, even though I am a manufacturer and that this black box, yes, I need it, but it's not so, you know, it's still in my factory. GDPR, at least in Europe, we think about its privacy as something extremely valuable. It's like it's something which on a constitutional level can trump everything. Not when it comes to these rules. The interesting thing is that if you have a right under some of this, like for example, the Data Act to access it, then you cannot probably deny access on the GDPR. There's an interesting new case regarding trucks. Scania, the Swedish truck company, said, we don't want to give data to independent repair shops, not dynamic data. Why? Because it's the personal data of the driver. And the court says, doesn't matter. So here, they have a specific right to access. You only have the general protection on the GDPR. The specific law, lex specialis wins, more or less. And so there's a lot of exemptions and a lot of different opinions in academia, whether there's too many exemptions or not. But that's the interesting thing. The very end, my last slide here. I think maybe we should make it less complicated. And maybe we are at the moment globally, but at least in Europe, and I definitely think in Hong Kong and other places, maybe we should have a proper property right to data. Not this extremely, all these different kind of laws, dealing pretty much with the same thing. However, we need to think about a new way of thinking about property. We're never going to get, cannot be an exclusive right. We cannot have exclusive right to words or like information, because that's public utility or public good. But the data you generate, you should have some way of controlling that. So that's what I suggest in the end of the book, to create an access and transfer right, ATR instead of IPR. And I do think it fits pretty much with the intellectual property legal system too. We can fit it in there. But I stop there. That's what I should talk about. Thank you very much.
Excellent. Thanks, Björn, for these great kind of overview about the complicated laws that we have in the EU, dealing with all these kind of different aspects of what is somehow the same kind of amalgamation of data and matters. But I'll pass over now to Sandra and for some comments, and then we can open the discussion.
Sorry. All right. So thank you so much for giving me the opportunity to act as discussant today. I have to say, I very much enjoyed your book. For for me, perhaps what was particularly helpful when I read it already a while back, I had to kind of dig it up again. So it's very good to join the dots for those of us who are familiar with these laws, but there's just so much out there, like you've just explained. I often go back to it just to remember how, you know, all these legislations kind of affect these issues and how they interact. The competition laws, the data protection laws, the digital specific rules. Now, you say yourself at the end of the book that there's a kind of negative outlook, some issues that need to be addressed, but you actually put forward, as you've just mentioned in the last slide, what seemed like a very common sense, feasible proposals to improve the regulatory framework. And this, what you mentioned, you emphasize the importance of access to data, the portability of data. So the first thing perhaps that I wanted to maybe discuss and maybe ask you about is, the book was published very recently in the grand scheme of things, but so much has happened, right? So I don't know if you've reflected on all the recent developments and the recent trends that we're witnessing, and whether that has made you see things under a different light, or if you think that your proposals are actually, you know, fit to address the new challenges. So perhaps one of the biggest things is all this talk about a possible rollback in the regulation. I don't know if this framework would be affected, but you know, pressure is coming on the one hand from within the EU. You know, from starting with the famous Draghi report saying, you know, well, you know, the EU has, you know, partly itself to blame for its woes, for not being competitive. Possibly this is due to over-regulation. And then there is the pressure coming from other parts of the world, you know, Trump tweeting or whatever it's called, truthing, I don't know what is social media, saying, you know, I'm going to impose tariffs on countries that have digital laws and are punishing the American companies. And then suddenly the Commission also seemingly a little bit hesitant, because it stopped, you know, it sat on the AdTech, Google AdTech decision for a couple of days, and then it released it and punished Google yet again. So in this context, are the priorities that you've identified, are they at risk? Is this something that we can still think about protecting? So that for me is really interesting, whether that has changed your view on things. The second aspect is, of course, since we are here now also, is, you know, China. So China has also been adapting its regulatory framework to digital issues. So we've seen, so we don't have, I think the big difference is perhaps we don't have, at least we don't yet have digital specific laws, but there is this competition law that was reformed in 2022 to include reference to the digital economy. We've got new data protection laws that make a lot of emphasis on these issues that with a little bit, you can see a lot of parallelisms with the GDPR. And recently the anti-unfair competition law was revised, and there is an actual provision on unfair methods of competition that refers to the use of data and algorithms as a way to engage in unfair competition. So companies cannot obtain data through fraudulent, coercive means, or abuse platform rules to instigate, for example, false transactions. So this is obviously, there are little references here and there. So that is perhaps the connection that's been made between the competition issues and data. Now, I don't know if you have had a chance to reflect on whether these proposals that you make might work in a jurisdiction that is, you know, seemingly the legal framework tells us, you know, worried about similar issues, and ready to make that connection, the connections that you've made, but from a different angle. So I guess that in Europe, perhaps one of the priorities is the individual rights. We have quite a decentralized model, the prioritizing competition, and China perhaps having a more like state-centric system where perhaps the data issues also relate to security and control. So I don't know the extent to which those proposals might work within that context. So those would be my main points. With that, I just really thank you for the wonderful presentation. Thank you so much.
Thank you. That was a lot of comments. Thank you. We can see if I remember it all, but no, great comments. Yeah, thank you. I agree with you everything happens so quickly. So,
Yes.
one thing was happened after the book was published. It's this total breakthrough of AI with Chat GTP and Claude. I use Claude. Yes, Claude is a friend. But interesting and the interesting thing in that is that we really see private cases. It's the copyright protection we're talking about. We see the collecting rights societies, both in the US, Europe, and I don't know so much in China, actually. I know a little bit China, but I don't know if they are claiming, going to court, trying to extract money from these because they're, the AI is using their data and they have a right to it. And in my world, that should also, we could almost maybe be able to do it under the data. Us that do not create copyright protected data. Let's say all the lawyers in courts. I mean, one of the big databases we'll always be fighting about, at least in Europe, is about court cases, court databases. It was one of the big first hits, selling access to court databases. Think about that, and now that's also used for the AI models. And that's often, depends on the jurisdictions, but often that is not copyright protected. It's one of the exemptions. Not in the UK, they have a Queen's right to it, whatever it kills, but in many jurisdictions, we should be able to use that to actually also gain remuneration from the AI models, because perhaps it will boil down to that. Yeah, the property right will not be an exclusive right; it will be a right to remuneration. So it's a right to get money. I haven't talked about that in the book, but probably that will. So in one way, we see this coming. Not due to my book. I don't think they read my book, but but it's due to that. And then, of course, we have the omnibus, which is it's the push to deregulate with Draghi's report and so on, and also with the Trump that they are hitting hard on the call it tariffs. I mean, and we haven't seen it in specific cases. You're right that probably the Commission was hesitant to deliver some decisions. And I think it's difficult it's about framing it. If we frame it as a property right for individuals, companies, and so on, to get money from AI and large platforms, it would be difficult even for Trump to say that is a tariff that we put on American companies. But we don't, I don't know. I also wanted to discuss it because I think this, what I know about China, I've had an excellent PhD thesis actually comparing GDPR in Europe with the Chinese data protection law. And his conclusion is that they're quite similar. So I talked about the Scania case there, which says if you have a right in one law, lex specialis, you have a right that cannot be trumped by GDPR. That was a big issue. And that is, I think, quite clear in the Chinese regulation. It says if you have a lex specialis, if you have a right to access the data, collect data or access the data, then that will trump the Chinese data protection. So I shouldn't say that Europeans should claim that they have so many more rights on the GDPR than actually the Chinese data protection. They're quite similar. So of course, I don't know all the lex specialis rules in China. But I do think that European governments do collect a lot of data too, obviously, or American companies, or American authorities. Yes, this unfair competition, there's an area I think which is very interesting in Asia with this enhanced bargaining power by certain, and there's something I would love to learn more. We don't have it in the Nordics. The non-Nordic company has this. We call it market law, and so there's some business practices which is flat out illegal come to marketing, but it's not as advanced unfair legal system as you have it in Korea or in Hong Kong, I think, in Japan and so on. So I think that they have it in Germany, though, but not in Nordic. But there's something I think could be utilized vis-a-vis platforms, and also in reference to Internet of Things. It could be used more. Yeah, I think I'll stop it.
Thank you so much.
Excellent. Thank you.